Hello and welcome. I'm Peter Afrasiabi, host of The Curious Lawyer, and today's program is part of our Bill of Rights series. We're on the Sixth Amendment today. Now, if you've been following along with our Curious Lawyer programs, you will have seen us take interesting walks down various different off-the-beaten paths of the law, from CIA law to the Secret Service law to even presidential pardons, and to your favorite friends, dog law. This series, however, is focused on the Bill of Rights, and so we have 1 hour devoted to each of the 10 amendments to the Constitution. I hope you've enjoyed the other amendments. Today we're on the Sixth Amendment. This is going to give you the opportunity to know everything you need to know about the Sixth Amendment. Many of us are civil practitioners. We don't really deal with the Sixth Amendment much. This is a great way to recap, remember, relearn what you learned in law school or for the bar, or perhaps you didn't. And so that when you show up at your next cocktail party, you'll know everything there is to know about the Sixth Amendment. So let's get going. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and course of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. We are going to unpackage this today, as you see here on our next slide, talking about the issues that we'll address. And fundamentally, what we're looking at are 4 different modules, so to speak. We have the right to counsel, we have a speedy and public trial right, an impartial jury right, and a right to confront the witness. And within each of these, there are some sub-issues that we'll look at. On the right to counsel, not only do you have a right to counsel, but then there's the embedded question, what about a good counsel? What happens if you have a really ineffective counsel? We'll also look at the line between criminal and civil and how far this right to counsel may have passed over the criminal line into quasi-criminal or even civil jurisprudence. On the speedy and public trial front, we're going to look at just how speedy is. We're going to look at whether this right to a speedy trial also applies to the right to a speedy sentencing once you've been convicted or pled guilty. And we're even going to get a chance to look at how the recent pandemic and the COVID issues may have created delays in the courts and what this means for the speedy trial right and whether their speedy trial rights have been infringed, because it turns out there's even been litigation over it. On the impartial jury front, we're going to look at jury peremptory challenges on improper grounds, the idea of what happens if you have public attendees wearing buttons or slogans looking to impact the jury, Zoom trials, and then we're going to have a fun little sidebar in terms of whether is there a perfect crime zone somewhere in the U.S. that actually evades the Sixth Amendment because of that right to an impartial jury in a state and district. Stay tuned. You may or may not get the answer today, but you're going to get teased with it for sure. Finally, there's the right to confront witnesses. We're going to look at the idea of screens and one-way mirrors in child sex abuse cases and how that's played out in terms of the confrontation clause and the right to confront those witnesses. And this then brings us, of course, into the modern computer video technology age, Zoom, where we have two-way Zoom obviously presentations that can occur with witnesses appearing in court where everyone can see them by Zoom, and how that has fared under the Sixth Amendment. So let's get going again. And just as a quick reminder, here is again our Sixth Amendment. I've bolded and underlined for you the 4 fundamental pieces that we're addressing today in these 4 core modules. And so we're going to get started with the right to counsel. And this is going to bring us, as we explore and walk through this area, into the right to a lawyer, the right to an effective lawyer, the criminal civil line, and then the child adult line, which has become a very important line in terms of triggering the right to counsel and has raised really fascinating issues, and some of which are on the cutting edge of the law now in the realm of immigration in particular, that we will be looking at momentarily. But let's get started with where we often begin in our Bill of Rights programs, and that is the incorporation doctrine. Fundamentally, the question is, does the Sixth Amendment apply to the states? And of course, the idea, as you recall, is that the constitutional amendments, the first 10, only apply to the federal government and not to the state governments. And so the question is, with the adoption of the Civil War amendments, specifically the 14th Amendment, the question then is raised, do the first 10 amendments to the Constitution apply to the states by way of the 14th Amendment's adoption? And does the 14th Amendment then, in effect, incorporate the first 10 amendments, or any of them, by way of the Due Process Clause of the 14th Amendment, and thereby make them applicable to the states also? And the basic test that the Supreme Court has adopted, you see it here from Griswold, reported at 381 U.S. at 499. This is one of the Warren error cases, that fundamental rights rooted in the tradition and conscience of our people, and thus implicit in the concept of ordered liberty, are applied to the states via the 14th Amendment. And so the Sixth Amendment, on the right to counsel aspect to it, has been held applicable to the states by way of the Gideon versus Wainwright case. And as it turns out, all aspects of the Sixth Amendment have actually been incorporated, except for one, and that is the right to a jury from the state district where a crime occurred. And that one has not been incorporated, perhaps logically, because within a state you have, if you're indicted under state law in a state court, you're obviously going to have a jury from the state where, or the county where you're sitting. So it doesn't even make particular sense, perhaps logically, to even look at incorporating it. So for all practical purposes, the Sixth Amendment has been incorporated. This gets us off and running to the Gideon versus Wainwright case, reported at 372 U.S. 335. It's from 1963. And here are the basic facts. Gideon was accused of burglary. He couldn't afford a lawyer, and he shows up in state court, and here's the exchange between the court and Gideon. The judge says, "Mr. Gideon, I'm sorry, but I cannot appoint counsel to represent you in this case. Under the laws of the state of Florida, the only time the court can appoint counsel to represent a defendant is when the person is charged with a capital offense. I'm sorry, but I'll have to deny your request to appoint counsel to defend you in this case." To which Gideon replies, "The United States Supreme Court says I am entitled to be represented by counsel." He didn't get his lawyer. Mr. Gideon goes to trial pro se. He loses. He gets a 5-year sentence, and he takes his case up to the Supreme Court of the United States. And here, because of the wonderful work of the OYES organization, we can actually listen to a few minutes of this oral argument before the United States Supreme Court by Mr. Gideon's lawyer. And so let's listen in here from the 1963 oral argument before the Supreme Court. And this will help you get a sense of the issues being framed in terms of just how important it is for people to have counsel. So here, let's listen to this.
Mr. Justice Douglas, it seems to me that perhaps I would state the proposition this way. And I do believe that it is a proposition that proves itself. That is to say, the 14th Amendment requires a fair trial. You cannot have a fair trial unless the defendant has counsel. Now, the QED, to me, is so obvious that I can't escape from it. And I can't escape from it by saying that the QED does not follow because of a principle of federalism. We start with the proposition that the 14th Amendment requires a fair trial, and we say that the defendant in a criminal proceeding cannot get a fair trial unless he has counsel, and it seems to me to follow without any possible escape hatch that he's got to have a fair trial. But I think I may be wrong about this, but I do believe that in some of this court's decisions there has been a tendency from time to time, because of the pull of federalism, to forget the realities of what happens downstairs, of what happens to these poor miserable indigent people when they are arrested and they are brought into the jail, and they are questioned, and later on they are brought in these strange and awesome circumstances before a magistrate, and then later on they are brought before a court, and there, Clarence Earl Gideon, defend yourself. Apply the doctrine of map against Ohio. Construe this statute of the state of Florida, which says that breaking and entering with intent to commit a misdemeanor is a felony. You should know, Clarence Earl Gideon, that the state of Florida, the Supreme Court of the state of Florida, has construed this statute, and it has made available to you various defenses. Well, really, how can Clarence Earl Gideon do it? I was reminded the other night, as I was pondering this case, about Clarence Darrow's trial. The court will remember that Clarence Darrow was accused and subsequently acquitted of attempting to bribe jurors in subornation of perjury. And I looked at Irving Stone's book. Irving Stone's book says that the first thing that Clarence Darrow realized was that he had to have a lawyer. Here was a man who, by our folklore anyway, and I think perhaps really was our greatest criminal lawyer.
Well, there you have it. That was a sort of fantastic capsule summary of really the issues that were confronting Gideon as framed by his lawyer and some of the back and forth with the court. And ultimately, what the Supreme Court held, you see here, is, and here's a quote from it, is that lawyers in criminal courts are necessities, not luxuries. The right of one charged with crime to counsel may not be deemed fundamental and essential to fair trials in some countries, but it is in ours. From the very beginning, our state and national constitutions and laws have laid great emphasis on procedural and substantive safeguards designed to assure fair trials before impartial tribunals in which every defendant stands equal before the law. This noble ideal cannot be realized if the poor man charged with crime has to face his accusers without a lawyer to assist him. Therefore, the constitutional right to counsel applies to the states in that case, and also to Mr. Gideon. His conviction's vacated, and he gets to go back and try again with a new lawyer. Now, this raises the question, you have the right to counsel, but what if the counsel's incompetent? What if you have what's known as an ineffective counsel, or ineffective assistance of counsel? IAC is the acronym often used. This we can explore through the 1970 Supreme Court case of McMahon versus Richardson. It's reported at 397 U.S. 759 from 1970, and the basic facts are as follows. The defendant is arrested, he confesses, enters a guilty plea, he's convicted, and then he's sentenced. Now, subsequently, he wants to collaterally challenge the fact that his confession that he gave the police pre-guilty plea, he now claims the confession was coerced. And so he has this sort of fundamental question now he's now raising, saying, I had a lawyer, but the lawyer didn't really address that issue, that my confession was coerced, it's not fair, the whole thing should be vacated because even though I pled guilty, I really had been the victim of a coerced confession. And so this then raises these big questions that exist for lawyers in terms of strategic questions. What do you do? How do you handle the defense of someone? And so the choice to go to trial and fight the validity of the confession was one choice, or to plea is another choice. And they're both filled with obvious uncertainties. And here's the quote from the Supreme Court. Questions like these cannot be answered with certitude. Yet a decision to plead guilty must necessarily rest upon counsel's answers, uncertain as they may be. Waiving trial entails the inherent risk that the good faith evaluations of a reasonably competent attorney will turn out to be mistaken, either as to the facts or as to what a court's judgment might be on the given facts. In our view, a defendant's plea of guilty based on reasonably competent advice is an intelligent plea, not open to attack, on the ground that the trial counsel may have misjudged the admissibility of the defendant's confession. And so what the court held then is that if the right to counsel guaranteed by the Constitution is to serve its purpose, defendants cannot be left to the mercies of incompetent counsel, and that judges should strive to maintain proper standards in the performance by attorneys who are representing defendants in criminal cases in their courts. And so this enshrined the idea that you have the right to counsel and the counsel cannot be incompetent. But as applied to that case, what the court held is that these are complex strategic decisions that are made. And you can't simply just second guess Monday morning quarterback, in other words, every decision of a lawyer and say that you could have been better off if you'd picked a different fork in the road. And so what the court was ultimately holding here is that, sure, you could have gone to trial and fought the confession and claimed that it had been coerced. And if the jury had disbelieved you, then you would have been, lying before the jury, and your punishment would have been way higher than you got on the plea. And that's just sort of the dilemma that everyone confronts. And so, a lawyer looks at it, weighs the pros and the cons, tells the client makes a decision. It is what it is at that point. And so that's an example of how, although you have the right to competent counsel or the right not to be victimized by ineffective counsel, courts aren't in the business of second-guessing every strategic decision of a lawyer. And so that's a very, very important part of the Sixth Amendment right to counsel rubric. Now let's take a look at the current test for how we analyze whether one has had effective or ineffective assistance of counsel. And this really comes from the seminal decision of the Supreme Court in Strickland versus Washington at 466 U.S. 668, 1984. And so Strickland basically involved these facts. You have a defendant who pleads guilty to 3 capital murder charges. Now in the plea colloquy, he tells the judge that although he had committed a string of burglaries, he had no significant prior criminal record, and at the time of his criminal spree, he was under extreme emotional distress caused by his inability to support his family. And the trial judge actually told the defendant, respondent, that he had a great deal of respect for people who are willing to step forward and admit their responsibility. And so this sort of conversation comes up in the beginning where there's an admission and the judge says, kudos to you, we like people who accept responsibility. The guy pleads guilty. You then fast forward to the sentencing hearing, and defense counsel has a strategic decision, obviously. What do? Do you seek out character witnesses? Do you request a psychiatric examination? Do you open up a full evidentiary hearing into his background, his full criminal background? Or do you go with the record that was there at the plea? And counsel decided not to present evidence concerning Mr. Strickland's character and emotional state because, believing that this could open Pandora's box, in other words, and make things worse, because then he would allow the state to cross-examine him and present its own evidence, and the situation could get worse, was counsel's basic analysis, given kind of the broader background of facts known by counsel, obviously. And so he didn't request a pre-sentence report, because then it would have included the full criminal history, which may have been somewhat inconsistent with what that plea colloquy hearing was, and would have fundamentally undermined the claim. And so he was stuck with that dilemma, and so he stood on the record as it was rather than fearing making the record worse. Sentencing comes, death sentence imposed for the capital murder charges, and counsel's choice is later challenged as ineffective assistance of counsel. This case works its way up to the Supreme Court, and the Supreme Court holds that the fundamental test here for assessing ineffective assistance of counsel revolves around the question of whether the lawyer's conduct was objectively reasonable given the totality of the circumstances. And that sort of is the fundamental test. It's got a couple embedded questions in it. The first question is that you have to show the lawyer was unreasonable in the legal advice and legal decisions, and therefore ineffective. And then the second aspect to this is sort of a causation question in terms of prejudice, which is if not for the lawyer's error, there would be a reasonable probability that the proceeding could have had a different outcome. And so you see, that's the fundamental test that exists. And what the Supreme Court held in Strickland is that a lawyer's tactical decision is not unreasonable if it's within a range of reasonable professional judgments, given the staggering aggravating circumstances. The idea of limiting a record to a plea colloquy helped keep out as much negative material as possible. And what the court also held, therefore, was that it wasn't unreasonable, but even if it was, there was no prejudice, the court held, because the outcome would not have been different in terms of death sentence being imposed, given the fundamental factual record that existed for that lawyer. And so this is an example, sort of the modern test for effective assistance of counsel analysis and the broad range of professional deference ultimately that's given to lawyers in terms of making very, very difficult decisions in very, very difficult fact patterns. Now let's turn and look at, what's the criminal line? And the Supreme Court has extended the right to counsel to children in delinquency proceedings. And so in these cases, because children are uniquely situated when facing sort of these legal rehabilitation-oriented regimes, there's some sort of a punishment that's befalling a child because of child delinquency cases. They're not technically criminal cases necessarily, but nonetheless, they're quasi-criminal. And because they involve children, the Supreme Court in In re Gault at 387 U.S. 1 in 1967 held that there is a right to counsel. So this now, as you can see, sort of expands us beyond the realm of criminal law into quasi-criminal, but ultimately civil court technically. And then it raises new questions. Okay, well, what about the right to counsel in other quasi-criminal, technically civil areas where there are massive issues on the line, right? I mean, you have children being punished or subjected to some sort of state-ordered regime to corral their behavior, but what about people in immigration court, for example, who are facing death if returned to a country of origin or torture if returned to a country of origin? And so they're facing massive, life and liberty type dimension questions. What about do they have a right to counsel? Now, as it turns out, they do not. Deportation is not deemed punishment, and so the court has ultimately held that the Sixth Amendment is not triggered, and so there is no right to a lawyer to be given you by the state, by the federal government, when you are placed into deportation proceedings. Now, what's very interesting is that coming out of the administrative courts, and then as a result of jurisprudence from the circuit courts, they have held that if an immigrant hires a lawyer, then the right to an effective lawyer actually attaches. And so this has come through as part of the Fifth Amendment's guarantee of due process. And so what it means is courts will not allow people to be deported as a result of ineffective assistance of counsel. And the reason this has been read into immigration cases is fundamentally because they do involve life and liberty. And so because they involve kind of these questions of constitutional dimension, although we don't give people lawyers, if they happen to hire one, we are going to demand the lawyer in that case provide effective assistance of counsel, otherwise they can get a new trial. As opposed to in our traditional civil cases where we have no right to a lawyer, but if you do hire a lawyer, your right to an effective lawyer is heard not by getting a new case if the lawyer commits malpractice, but by a malpractice remedy against the lawyer for money damages. And so the test then for effective assistance of counsel in the immigration context is, was immigration counsel's performance deficient and did it cause prejudice? Much like the Strickland test in the criminal realm. But here's the interesting question as we get to our next slide. What if you have a child who's in deportation proceedings? We saw children in juvenile delinquency type proceedings having the right to counsel. Now what do we do with children in deportation proceedings? Because the idea of being a child confronting a legal regime is fundamentally different to an adult. And so this has actually been taken up to the Ninth Circuit in CJLG, a juvenile male versus bar. That's the acronym of the petitioning child. It's reported at 923 F. 3rd 622. This comes out of the Ninth Circuit in 2019, and this case went en banc. And basically, the basic facts are as follows. You have a child who's held at gunpoint and threatened with death because he refused to join a Honduran gang, given all this sort of Honduran street gang violence. The child and his parents flee to the U.S. They seek asylum and protection under the Convention Against Torture. They lose, they're ordered removed, but they argued that they should have had counsel given for the child. And the child didn't have the ability to himself press his claims and protect his rights, and the parents are not lawyers, obviously, and so he should have had the right to counsel. Now, the majority in the Ninth Circuit did not address this issue, but the concurrence did, and the concurrence argued that the Fifth Amendment guarantee of due process must necessarily guarantee children in removal cases the right to counsel too. And so it's a massive published concurring opinion, which really now leaves a big, big open question in this area for future litigation to decide whether the fundamental guarantee of the Sixth Amendment right to counsel, which has been extended to children, will now be further extended either directly via the Sixth Amendment or through the Fifth Amendment guarantee of due process to children in deportation proceedings. And as one can imagine, it's a massive question with massive consequences given the many, many thousands of children, obviously, in civil, these quasi-criminal but civil deportation proceedings. And there'd be a massive need for lawyers. It'd be the Full Employment Act for future budding law students who want to go to law school. There'd be no shortage of hiring demand by the federal government for defense lawyers. We will wait to see what happens. Now, this lets us move to our next module, which is the right to a speedy and public trial. As noted, this has also been incorporated by reference via the 14th Amendment and applied to the states. And what we're going to look at as we explore this little module of ours is the scope of a speedy trial, right, and what it means, whether it applies to a trial but also a sentencing. And we're going to look at sort of one aspect of public and the limits of public trials in terms of cameras in the courtroom and kind of the historical ebb and flow in terms of what has happened with some famous cases through history where there have been a massive presence of cameras and the damage that's been done to the court's perception of justice and ensuring justice. And then we're going to look at, we're going to end by looking at kind of our recent COVID pandemic protocols, what had happened, the impact of them, and some litigation over whether that violated the speedy trial right. So let's get started though first with what is a speedy trial? Well, the scope of this right is triggered at the point at which a prosecution begins, and it only applies to those accused. So when a prosecution starts, then you have this right to a speedy trial, but it only applies to you if you've actually been charged. Unnamed potential people who could be subjected to future charges don't have a speedy trial right that's attached yet. Now, this can attach pre-indictment at the time of arrest also. And here you see from Beavers versus Hobart, 198 U.S. 77, at page 87. This is from a 1905 Supreme Court case describing it. And here's what the quote is. "The right of a speedy trial is necessarily relative. It is consistent with delays and depends upon circumstances. It secures rights to a defendant. It does not preclude the rights of public justice." And so what the Supreme Court has long held is that this is not a sort of fixed litmus test where there's X number of days by which you have to go to trial, otherwise the case gets dismissed. It's fundamentally one that's reflective and reflexive of the factual circumstances of this person in this case, and then the need for the government to ensure justice of the person. And so at root, it's highly fact intensive, and no amount of time is per se too much. Now, what's happened over time is that the Federal Speedy Trial Act has been adopted, and this statutory scheme has effectively supplanted most of the constitutional inquiries or challenges that happen. And so we have a very complex and detailed statutory scheme that requires that, within 30 days of arrest, an indictment needs to be filed. And there's similar statutes in most all states. Trial then has to begin within 70 days from the indictment, but not less than 30 days from when a defendant first appears in court. Pretrial motions will be excluded from the count, and so if you have 60 days to address some pretrial challenges, that tolls the count, in other words. There also can be delays due to co-defendants, unavailability of witnesses, which won't count in the time calculus. The parties can also stipulate to extend the time. And so basically, it's a framework that envisions the need to move things along at relative pace, but recognizing the fact that there can be delays, and there will need to be delays for a whole variety of reasons. And so this is our sort of codified positive law enactment to address the wide bandwidth the Supreme Court has given in that Halbert case from 1905 in terms of recognizing the balancing on both sides. Now let's look at the question of speedy trial versus speedy sentencing. And we can see this in a 2016 case, Betterman versus Montana, at 578 U.S. 437, and here are the basic facts. The defendant pleads guilty to bail jumping after failing to appear in court on a domestic assault charge. He's then put in jail and spent 14 months awaiting sentence, in large part due to institutional delays and other issues that were going on. He was then sentenced to 7 years imprisonment with 4 of the years suspended. He argued that the 14-month gap between conviction and sentencing violated his speedy trial right. The Supreme Court held that the speedy trial right does not apply once you're found guilty. In other words, the right detaches at that point. The speedy trial right only attaches at the point of arrest up until the point of conviction. And at the point of conviction, your Sixth Amendment right to a speedy trial, now that right ends, it detaches, it doesn't exist. But what the court did hold is that if there was sort of staggering delay, at some point the Fifth Amendment would step in, and sort of the guarantee of due process would ultimately step in and say that you can't be held for staggering delay. But no one felt in that case that the 14 months was staggering delay given those fact circumstances of what Mr. Betterman was confronting. Now let's look at the other aspect to public trials here, which is sort of cameras in the courtroom and what happens. And so we have Richmond Newspapers versus Virginia, and this is at 448 U.S. 555. This is in 1980. And so basically the idea is that trials have to be open to the public, but this touches multiple constitutional issues, from due process guarantees to First Amendment access to the press. And there's fundamentally a presumption of openness that inheres in all criminal trials. And what we had in this case is, this is a quote in terms of the historical background, in terms of what the court had concluded in terms of where this right comes from. And this is sort of a great look at the history of public trial right. The historical evidence demonstrates conclusively that at the time when our organic laws were adopted, criminal trials both here and in England had long been presumptively open. This is no quirk of history. Rather, it has long been recognized as an indispensable attribute of an Anglo-American trial. Both Hale in the 17th century and Blackstone in the 18th saw the importance of openness to the proper functioning of a trial. It gave assurance that the proceedings were conducted fairly to all concerned, and it has discouraged perjury, the misconduct of participants, and decisions based on secret bias or partiality. Civilized societies withdraw both from the victim and the vigilante the enforcement of criminal laws, but they cannot erase from people's consciousness the fundamental, natural yearning to see justice done, or even the urge for retribution. The crucial prophylactic aspects of the administration of justice cannot function in the dark. No community catharsis can occur if justice is done in a corner or in any covert manner. That's at 569 to page 71. That's the sort of the fundamental root, fantastic sort of explanation for why we have this presumptionness of public trials and why they're so important for both defendant, victim, and society as a whole. So let's look at cameras in the courtroom and what's happening. We're going to go all the way back to the famous Charles Lindbergh baby kidnapping and murder case, up to a very, very famous 1965 Texas fraud trial, kind of the Enron of its day, so to speak. So let's start with State versus Hauptman, and this is from New Jersey, 1935, and Mr. Hauptman was charged with kidnapping and murdering the Lindbergh baby. And as you know, you all know, obviously this was a very, very sensational trial of that time period. And what happened in that case is that then photographers were all over the courtroom, and quite literally the reports say that photographers were climbing over the courtroom tables trying to get the right angle to take photographs of the witnesses. Witnesses were being blinded by the massive flashing bulb lights of the day. And if you go onto YouTube and or Google, you can do a search and find some fantastic photographs from the time of the courtroom. And so what happened is that the defendant then argued on appeal that he was fundamentally denied a fair trial because of the press melee. Now, he lost and this was rejected, but what immediately happened in the aftermath of that is that the ABA and a whole variety of states started adopting rules saying that we have to restrict cameras in the courtroom and the broadcast of trials because this doesn't work and this really is damaging sort of the fairness of the trial process. This then brings us, you fast forward a generation plus to 1965, and you have the famous case of Estes versus Texas. And this was sort of a sensational financial fraud trial of that time period. It was kind of, what Enron was, or even what we're about to experience with SBF and FTX and the crypto meltdown stuff that's occurring in 2022 and 2023 when all those fraud trials will come. Estes versus Texas was that era's, crypto Enron event. Sensational financial fraud trial. The judge allowed TV and photo coverage of the trial inside the courtroom, and there were cables and cameras and camera crews and recorded devices all over the courtroom. The defendant's convicted, and then he appealed. And here's a quote from the Supreme Court, and I'll show you on the next slide a picture of the courtroom, which is fascinating to see. But what ultimately the Supreme Court held is that television, in its present state and by its very nature, reaches into a variety of areas in which it may cause prejudice to an accused. Still, one cannot put his finger on its specific mischief and prove with particularity wherein he was prejudiced. So there's this idea that it causes some level of mischief in terms of the intrusiveness, the impact on witnesses, emboldening or scaring. And although you can't put your finger on it exactly, there is this feeling that it can cause mischief and prejudice, and so we must be careful. And so here you see a photograph taken from the Estes versus Texas trial in the trial courtroom in Texas, and you can just see there cameramen all over the place, multiple big, massive video cameras for the television broadcasting. There are cables all over the place, and it just sort of starts taking on the air of a Hollywood set or a Disneyland, location more than it does perhaps a courtroom. And so here's what the Supreme Court said in Estes. As has been said, the chief function of our judicial machinery is to ascertain the truth. The use of television, however, cannot be said to contribute materially to this objective. Rather, its use amounts to the injection of an irrelevant factor into court proceedings. In addition, experience teaches that there are numerous situations in which it might cause actual unfairness, some so subtle as to defy detection by the accused or control by the judge. Number one, the potential impact of television on the jurors is perhaps of the greatest significance. Number two, the quality of testimony in criminal trials will often be impaired. Number three, a major aspect of the problem is the additional responsibilities the presence of television places on the trial judge. Number four, finally, we cannot ignore the impact of courtroom television on the defendant. Its presence is a form of mental, if not physical, harassment resembling a police lineup or the third degree. And so as a result, Estes' trial was found unconstitutional, and this then led to a broad ban on cameras and public television broadcasting of cases really around the country with other reversals on similar facts in other cases. Now, the modern rule is that all 50 states have a variety of rules that preclude cameras in courtrooms but allow them under certain circumstances, and fundamentally it's in the discretion of the trial judge to figure out what the trial judge is going to do or not do. Which is why, as we've all experienced over the last 20, 30 years, we were able to watch the OJ trial and we could see the pros and the cons and the benefits and the melee that may have come from it. We saw the recent Johnny Depp, Amber Heard defamation trial that was sort of broadcast, and we can all, judge for ourselves the validity or viability of the nature of the trial as a result of it being broadcast and what you think may happen with witnesses. But nonetheless, it's now within the realm of the discretion of a trial court to decide what they will allow and not allow and how they'll do it. On the federal side, Congress amended federal laws to allow federal judges some discretion to permit coverage or to reject it. And so, it's entirely up to the discretion of the federal judge to allow or not allow a trial. And most of the time in federal court, we just don't watch, we don't get to sit down on TV and watch federal trials. It's very, very rare that they're broadcast in any way. Most of the way, even to this day, the most recent, for example, Michael Avenatti proceedings and hearings, if you weren't there in court and you wanted to know what was going, you literally could follow real-time Twitter from one of the reporters in court tweeting what was occurring, in the case, and that's how you kind of learn. Now, some exceptions, of course, exist, and that is when you get to the circuit courts, the Ninth Circuit has live video feeds in real time of all oral arguments that we're arguing our appeals, and you can go back and even watch, the recordings of them in the, to see what's happened in past cases if you want. Those are all fully preserved, and most circuits tend to do that, feeling obviously that the idea of recording an attorney oral argument obviously doesn't raise the same issues about procedural due process and constitutional rights for accused in front of jury trials and the like. Now let's take a look at suspensions and emergencies, COVID and court battles, and what's happened with some of the speedy trial stuff as a result of our recent experience in the pandemic. And so obviously we had federal and state courts suspending jury trials in civil, in cases, in criminal cases being delayed during the COVID pandemic. And in the Central District of California, one of our judges, Judge Carney, disagreed with these sort of delays to jury trials and continuances on jury trials. And the defendant in one of his cases sought a speedy trial The government objected that the criminal jury trials were suspended due to the COVID rules and the central district's COVID suspension, and argued that obviously the trial has to be continued. And this is the case of United States versus Olson at 467 F sub 3rd 892 from the Central District of California, 2021. And what Judge Carney said is that it's simply not a physical or logistical impossibility to conduct a jury trial, and therefore a continuance was denied. The district court requested then that the chief judge of the Central District summon jurors for Mr. Olson's trial. The chief judge said no and explained that the majority of the Central District judges had approved a general order suspending jury trials. A voir dire panel was not going to be called up. Court personnel weren't going to be placed in jeopardy due to the COVID pandemic. And so as a result, there would not be a jury trial. And Judge Carney had said, well, no, we absolutely could. The district judge, the Central District said, nope, no jury is going to be given. And so Judge Carney said, okay, fine, I'm dismissing the indictment then. And so dismissed the criminal indictment against Mr. Olson. Now, on our next slide, as you'll see, the case doesn't stop there because the United States attorneys took this up to the Ninth Circuit. And in 2022, at 21 F 4th 1036, the Ninth Circuit reversed Judge Carney. And what it held is that the speedy trial and the right to a jury trial can be suspended in extreme situations. And that the district court fundamentally failed in the context of the pandemic to do a proper balancing of whether the ends of justice were served by granting a continuance and what was the best interest of the public and the defendant in convening a speedy trial. An en banc petition was filed and it was denied, but there was a dissent, and the dissent echoes what Judge Carney was getting at, which is even in the midst of a pandemic, there are some things that in a constitutional republic should be all but unthinkable. Ordering the closure of all houses of worship, for example. This case presents another such example, the wholesale suspension of criminal jury trials. Nonetheless, an cert petition was filed and the Supreme Court denied review in May 2022. This brings us to our next module, impartial juries and the governing principles. And this fundamentally gets to the idea that we pick juries from a representative cross-section of the community, and this is an essential component of the Sixth Amendment right to a jury trial. And this is from the Taylor versus Louisiana case. And this really applies to the overall panel that distills into the jury. And it's not a right to the composition of the resulting jury, but the panel from which you pick a jury must be representative of a fair cross-section of the community. And so the test for a fair cross-section comes from, it's articulated in Dern versus Missouri at 439 U.S. 357 at page 364, and this is what Dern says. In order to establish a prima facie violation of the fair cross-section requirement, the defendant must show, number one, that the group alleged to be excluded is a distinctive group in the community. Number two, that the representation of this group in veneers from which juries are selected is not fair and reasonable in relation to the number of such persons in the community. And number three, that this underrepresentation is due to the systemic exclusion of the group in the jury selection process. So it's a complex test to figure out if we're getting a fair cross-section. And the fundamental rule here is that we must have jurors that are unbiased. If there's pressure or influence over juror action, then it violates this requirement of an unbiased jury. Now, one issue of particular importance where this comes up is in the context of alleged confessions by defendants to crime. And what the court has fundamentally held is that if a jury sees a confession in testimony, but then later on the court deems that confession wasn't viable, it needs to be excluded from the case, that is the type of bell that cannot be unrung once heard. And so that would forever, in other words, poison the well, and there's no possible way a jury could really maintain impartiality at that point. And so as a result, what the courts have held and what the Supreme Court has held is that the court must first adjudicate the voluntariness of an alleged confession before a jury hears about it. And so the courts must hold evidentiary hearings, figure this out before a jury is ever allowed to hear it, because it's such powerful evidence that if to be taken back, it couldn't be taken back, and you now have a biased jury. That's the Jackson versus Deno case at 378 U.S. 368, 1964. So let's take a look here at the voir dire process, because voir dire is where we ask jurors questions. And the whole goal of it is to ferret out bias to ensure, fundamentally in our criminal cases and also in our civil cases, but for purposes of the Sixth Amendment, it's our criminal cases, that we're ferreting out bias, that we're not having biased jurors. And so the three major legs to the stool that are looked at from the perspective of bias is figuring out the backgrounds of the jurors, their life experiences, and then their opinions, beliefs, values. And those are the three legs to sort of the voir dire stool that we can use to really figure out, can this potential person bring fairness to this enterprise, or is there something about their unique background, experience, opinions, values, belief sets, and whatnot that would lead them to being biased? And you see here a really fascinating chart in terms of voir dire practices, which looks at, and this comes from the Judge's Journal in 2008, but it looks at the difference between state and federal courts and both who conducts voir dire. Is it exclusively by the judge, exclusively by lawyers? Is it balanced? And I'll tell you, just personally, I've had experiences where most of the time the judges do some and we as lawyers get to do it also, but I've also had experiences where we weren't allowed to and the judge was the only one that did voir dire. But you see the breakdown there in terms of, on our chart, who does it, how it's done, the methods of it, and also the number, of jurors that get impaneled, and the number of peremptory challenges. So it's just a fascinating little chart that you can see to see the divergence between the state and federal regimes in terms of what we're doing to ferret out bias as we look at potential jurors. This brings us, of course, to race and gender and jury selection, the seminal case of Batson versus Kentucky, 476 U.S. 79, 1986. And here we're looking at what happens when the cross-section requirement is unfairly tilted one way or another due to peremptory challenges that exclude people of race or gender and create then an imbalanced pool of potential jurors. And so in this case, we have a criminal trial in Kentucky. The defendant's a black man, and the judge conducts voir dire of the jury veneer and then starts excusing certain jurors for cause. And at that point, then, the prosecutor had the right to use their number of peremptory challenges, and the prosecutor strikes all four remaining black people from the veneer. So you now have a jury composed only of white people. This was challenged as violating the Sixth Amendment guarantee of a jury that would come from a proper cross-section of society. And the Supreme Court held that there is, of course, not a jury trial right to have a trial composed of only people of your race, but members of the defendant's race cannot be excluded on the basis of their race. And that simply is unconstitutional. It denies a fair jury trial under the Sixth Amendment to the defendant, but it also results in, unlawful discrimination fundamentally against the jurors who are excluded. And so the test that then devolves or results from this is that a defendant can establish a prima facie case of purposeful discrimination solely on evidence concerning the prosecutor's exercise of these challenges at the defendant's trial. The defendant has to show that he's a member of a cognizable racial group and that the prosecutor exercised peremptory challenges to remove from the veneer members of the defendant's race. The burden then shifts to the state to come forward with a neutral explanation for challenging the jurors. The prosecutor may not rebut a prima facie showing by stating that he simply challenged the jurors on the assumption that they would be partial to the defendant because of their shared race, nor can the prosecutor simply assert his good faith in individual selections. In other words, I don't know, I just didn't like the person. I mean, they're going to have to come up with more. Now, this has been extended to gender, of course, in J.E.B. versus Alabama, another seminal Supreme Court case. Now, there are limits on bias, and there's the no impeachment rule. And here, basically, the inquiry is that once we have a jury impaneled, inquiry really forbids the impeachment of questioning a verdict by that jury by looking into the internal deliberations of a jury. And so the no impeachment rule aims to promote full and vigorous discussion by jurors and to preserve the stability of jury verdicts. And so it's limited the ability of criminal defendants to argue that a jury's internal deliberations somehow demonstrated bias. In other words, what it means is once we impanel a jury, it becomes a bit of a black box and the system just systemically says they do their thing. We're not going to look into what they're doing to find ways to undo what comes from it. Now, there are exceptions for the gravest of circumstances, but they have to be pretty grave. And so you can see here in the first one is that If jurors are under the influence of drugs or alcohol, that's not enough to find a violation of the Constitution or find that you had an impartial jury. That's Tanner versus United States, 483 U.S. 107, 1987. But if you have a juror who's made anti-Hispanic statements in deliberations towards the defendant and witnesses and made really clear statements of racial stereotypes, that can require the no impeachment rule to give way. And that's the Pena-Rodriguez versus Colorado case from 137 Supreme Court at 865 that you see cited here. But it's really the gravest of circumstances where you have a juror who is involved in case-specific blatant racism like that can allow us to sort of open the box to what's going on in deliberations. Otherwise, very, very hard to do. Quick little sidebar here. We talked earlier about an impartial jury of the state and district wherein the crime shall have been committed. That aspect has not been incorporated, as you may remember. But here's the question. What happens if there's a state and district where there's an overlap such that a jury is called from another state? This actually can happen when you're talking about the District of Wyoming. The District of Wyoming covers all of Yellowstone National Park, and as you can see here on our slide, Yellowstone National Park creeps into Idaho. And so that little sliver of Idaho is in the District of Wyoming. And so what happens if one commits a federal crime while on that state of Idaho, but on the sliver that would take you into Wyoming? How do you get a jury from Idaho to hear the case in Wyoming where it turns out no one lives in that portion of Idaho? Well, the question then this raises is there a perfect crime zone where you can get away with murder right there on that little pink sliver of Idaho that I've coded for you? The answer is you got to watch another one of my CLEs to find out. If you go watch The Perfect Crime, is there a twilight zone in the Yellowstone National Park free from any law? Go watch that CLE, you'll find out the answer to that fun question in another one of our Curious Law programs. That, however, is the one aspect to the Sixth Amendment that's not been incorporated. Let's move along. Confrontation clause, our final module today. Three fundamental purposes are served by the confrontation clause: to ensure that witnesses would testify under oath and understand the serious nature of the trial process, to allow the accused to cross-examine witnesses testifying against the defendant, and to allow jurors to assess the credibility of a witness by observing that witness's behavior. And so what's critical here is that the perception that confrontation is essential to fairness has persisted over the centuries because there is much truth to it. That's Coy versus Iowa, 487 U.S. 1012, 1988. This idea that we must be able to face-to-face confront witnesses in an open courtroom, and that's how we get to the truth of things. It's how we've solved problems for hundreds, thousands, millennia of years, right? That is just simply a fundamental truism to our system and the confrontation clause. It takes root then in our hearsay questions. What do we do when we're dealing with out-of-court statements? We recognize common law exceptions to the confrontation clause's requirement if a witness is unavailable, but during previous judicial proceedings had testified against the defendant and the defendant was able to subject him to cross-examination, then we'll say, okay, fine. You had your chance to question the person in another case. That out-of-court statement then can come in and be used, and it doesn't deny you your confrontation clause, but that's because the prejudice has been addressed. Or, for example, in Smith versus Illinois, that's another example where a trial court can exercise reasonable judgment in determining when a subject of cross-examination was exhausted, and then they have a duty to protect witnesses from exceeding the bounds of proper cross-examination solely to harass or humiliate them. So, there are limits to confronting your accused if you're reaching the point of abusing or humiliating or, causing other types of things. And a judge actually gets to use discretion to decide that. Nonetheless, for that trial to be fair and the confrontation to have occurred fairly, you have to give cross-examiner reasonable latitude, and you cannot limit it in a way that would render it meaningless. This gets to screens at trial, Coy versus Iowa. Here, the defendant was charged with sexually assaulting two 13-year-old girls. The state moved under a state statute to protect child victims of sexual abuse to put up a screen between the defendant and the girls during their testimony. This blocked him from their sight, but it allowed him to see them and to hear them. So it was a one-way screen. Supreme Court held that the right to face-to-face confrontation was violated since the screen at issue enabled the complaining witnesses to avoid viewing appellant as they gave their testimony. there's no merit to the state's assertion that its statute creates a presumption of trauma to victims of sexual abuse that outweighs appellant's right to confrontation. Even if an exception to this core right can be made, it would have to be based on something more than the type of generalized finding asserting here, unless it were firmly rooted in our jurisprudence. This shows the importance of the Confrontation Clause and just how powerful it is then. Now, what about separate rooms, CCTV to trial? This brings us to Maryland versus Craig, where you have a state procedure that said rather than have a child testify in the courtroom, they would be examined in a separate room by the prosecutor and the defense counsel in the room with the child. It's displayed by video feed all into the courtroom so that the defendant can see the child testifying, the jury can see them. The defendant's lawyer is there to cross-examine the child in this other room. And that procedure, the Supreme Court said, was acceptable because in that case, if it was found to further an important public policy, then it could be supported. And so basically what the court held is that the Confrontation Clause doesn't prohibit a state from using this closed circuit television procedure if the child witness in a child abuse case is one where the judge has found that there could be profound emotional harm to testifying, wouldn't be able to communicate properly in court as a result, and because there's cross-examination going on in the other room, the defendant's Confrontation Clause rights could be abridged in that way. But note again here, what happened ultimately then is that the witness did not confront face-to-face the defendant. The defendant wasn't able to look at the witness as they gave testimony and be there in the courtroom to make that challenge. And that ancient idea that we've had about putting people in the same room to confront accusers and the importance of it in the search for truth has bent in these types of cases, such as Maryland versus Craig, when it comes to closed circuit television. What about Zoom? We have a split of opinion on Zoom. Zoom in the COVID pandemic obviously has become huge, and we have some cases such as this one from Minnesota here where on very, very specific facts, because an officer wasn't available, the judge allowed testimony to go forward and that didn't violate the Confrontation Clause. But we have other cases from Missouri, for example, where Zoom was used for witnesses testifying against a defendant on statutory rape, and that was held to violate the Sixth Amendment and voided the conviction. The technology is just such that courts are split on this. It's going to continue to become a massive percolating issue in our modern new Zoom technology era. And this really gets to sort of technology in the future of the Sixth Amendment. And you can watch here this little short video, which is funny and interesting. Go ahead and watch it.
Ponton, I believe you have a filter turned on in the video settings. You might want to take
we're trying to, can you hear me, Judge?
I can hear you. I think it's a filter.
It is, and I don't know how to remove it. I've got my assistant here. She's trying to, but I'm prepared to go forward with it. I'm here live. I'm not a cat.
I can see that.
Got on the Zoom. Everything seemed fine.
Hilarious. You probably all saw it during COVID. The lawyer is a cat and all that. And it's obviously funny, but it really does get at a very subtle and important new issue that's emerging with respect to technology. And that is that we can alter who we are and how we present and make us look different. Obviously not a cat, but what if I made myself look better, nicer, perhaps more of a victim? There's all manner of things one can do with Hollywood glamour and whatnot that could be very, very subtle. If you just go look at the YouTube Tom Cruise deep fake videos, you'll be blown away to see what you think is Tom Cruise when it's not Tom Cruise. And so this raises new issues. The other issue it raises, for example, is the ability to be in a room and have others coach you or provide you notes that the jury wouldn't see. And so, for example, this is software that actually I've created called Cicero Now. But it's a software program used for oral arguments for us as lawyers, mediations, depositions, wherever it could be of value. And it has communication protocols in it where, I could have an associate arguing a case and I can be on Zoom and I can be delivering a message to my associate, say this, don't say that, and only my associate sees it. And my associate has also got pre-populated content so they can stare into the camera and deliver really well. It's a sort of this to be a better advocate delivery software system. But imagine if it was used improperly at a trial, the witness could be getting messages given to them, could be reading off a script, And that would be done over Zoom, and the people on the other end, the jury, would never know. And so it'd be an example of sort of an improper use of technology. And these are the types of things that courts have to be very, very leery about and very, very concerned about as we enter this massive new technology age. That's the shameless plug for my software at sisternow.com. Thank you. Conclusions. Well, what we have today are the 4 core pillars to the Sixth Amendment: speedy public trial, confrontation clause, fair impartial jury trial, and the right to counsel. On the right to counsel, we saw limits. We saw the limits as they extend to children in certain juvenile proceedings, but not immigration, and we see the law really being tested now. We see on the confrontation clause side, technology really challenging the Sixth Amendment's boundaries, and it'll continue to do so in the modern Zoom technology age. We saw on the impartial jury and bias front how important voir dire is and how critical it is to make sure we get a fair jury. We also saw the no impeachment rule and how it becomes almost a black box event subject to very, very limited exceptions. And finally, we saw speedy and public trial and how it's been tested for the first time in probably a century by the most recent pandemic emergency, and how courts have responded to it, really holding in favor of broad rules allowing suspensions of jury trial rights due to the national emergencies that occurred. Thank you for watching this Bill of Rights Curious Lawyer program on the Sixth Amendment. Check out all our other programs. I'm Peter Afrasiabi, and as ever, if you have questions, please email me. Thank you.